Gonzalez. Reyes. Aye. Reyes, aye.
Great, and we will put that bill on call. Thank you so much, Assemblymember Jackson. I know you have ACA 7 up next, so you can go ahead and get started. I know we'll have some folks transitioning.
Thank you very much, Madam Chair, committee members. This is ACA 7, which is a Black Caucus priority bill, which aims to clarify Section 31A of the California Constitution to curtail the abuse and misuse resulting from its improper application and to ensure the constitutional provision aligns with the voters' intention in 1996. With me today to speak on the impact of this bill is Thuy T. Nguyen, education lawyer and partner at Garcia Hernandez Solney.
Good morning, Madam Chair Perez, committee members. My name is Thuy T. Nguyen. I am an education lawyer with a specialty in education equity for more than 25 years. I have served as general counsel for several organizations and institutions, including for the California Community College State Chancellor's Office. I have also served as a community college president. Is the state of California interested in closing the student racial equity gaps so that all students, no matter their background, can and will succeed? Is that interest compelling enough that Californians are willing to allow and enable educators at their local schools and colleges to have the tools they need to close the gaps? There is a wide range of tools, strategies that educators are using to close the racial equity gaps to ensure that all students can achieve regardless of their race. This set of tools, non-race-based, under Prop 209, are being used by our public educational institutions. These tools address various aspects of the students and their individual needs. And then there is this set of tools, race-conscious and some race-based tools that are tailored to address another aspect of the racial equity gap, race itself, instead of being blinded by the realities of such gaps. These tools have clear research and evidence of significantly narrowing and closing racial student success gaps. These tools look at the whole child. There are some courageous educational leaders among us who feel that it is morally compelling to explore these race-conscious strategies after exhausting all these other tools here, and to do so legally without running afoul of the Equal Protection Clause of the U.S. Constitution or even Prop 209 of the state constitution. As the California Appellate Court in American Civil Rights Foundation versus Berkeley Unified School District's school integration case stated, not all race-conscious actions are meant to be eliminated by Prop 209. That is why ACA 7 clarifies what is already legally allowed, but educators are too fearful to employ. And then ACA 7 also amends, sending a clear message to public educators that we want our schools and college to use all the tools that they know will work as long as they do so without violating the Equal Protection Clause of the U.S. Constitution. ACA 7 will do just that. Thank you to Assemblymember Jackson for championing this important measure. I am available to answer any questions that the committee may have.
Thank you for your presentation. I will now hear from any other support witnesses in the room. If you could please use the mic at the railing.
Raquel Morales on behalf of Trust West and Strong Support, also doing a Me Too on behalf of Californians Together, Southeast Asia Resource Action Center, Black Educator Advocates Network, and Young Invisibles.
Sadabatis with Children now in support.
Dominique Dene with Ed Voice and Support.
Rachel Murphy with Public Advocates in Support.
Clara Medina Maya with Californians for Justice in Support.
Good morning. Maria Madril Hernandez with Central Valley Movement Building Organizing Institute in Support.
Anybody else? We will now hear from witnesses in opposition. If we have 2 witnesses in opposition, please come forward. Alrighty. You'll have 2 minutes each.
All right. Thank you. Good morning, Senators. I would like to start with one simple question for all of you, especially the Democratic members of this committee. Under which scenario would you think California public agencies should be allowed to discriminate against Californians on the basis of race or ethnicity? Remember, we require equal opportunity instead of equal outcome. I can't think of any, none. California voters have responded resolutely on the state ballots twice, with the second one showing stronger bipartisan support for Proposition 209. Please do not push another bill for racial discrimination again. This is not the hill the Democratic Party should die on. This hyper-partisan intent to discriminate on the basis of race is so blatant that many Democratic voters have reached out to my organization to express their discontent with this party and its far-left tendencies. Just check out the recent pledge signed by hundreds of UC professors to ask for the reinstatement of SAT and ACT. The number of registered Democrats on the list is very high. Racial discrimination policies have consequences. Senators, I urge you to connect with your base and your electorate by considering the voice of reason and moderation. In 2020, all prominent Democratic leaders endorsed Proposition 16. Yet 57% of California voters voted no on the proposition. Almost all but only 6 California counties went against it. Just do the math, about 36% of Biden voters voted to keep Prop 209 in place. The math itself is compelling. California has affordability, homelessness, and basic public services issues. Voters have elected you to solve these problems, not to reintroduce discrimination. If ACA 7 were to be passed, education institutions would be able to make financial aid decisions based on immutable characteristics such as race. But shouldn't they determine a student's financial assistance based on individual need? Handing aid out based on race is fundamentally unfair and immoral. Last but not least, my organization, Californians for Equal Rights Foundation, has been actively filing lawsuits against public agencies for their race-based programs. We have been quite successful in the past 6 years in confronting and stopping racial discrimination in courts. We will be ready to sue the state and any public entity that implements ACA 7. Thank you. And I respectfully ask you to vote no on this bill.
I'm Gail Harriet. I'm a law professor emerita at the University of San Diego. I oppose ACA 7 for so many reasons, including these 3. 1, it will lose. The previous effort to gut Prop 209 went down in technicolor flames in 2020, with more than 57% of Californians voting no. And here's the kicker. That's despite the fact that the yes side outspent the no side by more than 14-1. If anything, ACA 7 is even more likely to be defeated since its most important effect will be to authorize financial aid discrimination, which, with the exception of reparations activists, hardly anybody supports. Ask me about that. I can tell you a lot more. Number 2, even if it wins, it will lose in court. In 2023, the Supreme Court's 6-3 decision in Students for Fair Admissions held race preferences in admissions to be unconstitutional. But the court's opinion was very broad, stating, and I'm quoting here, eliminating race discrimination means eliminating all of it. Ask me about that again. All of it, not some of it, all of it. Number 3, When this bill was introduced, the plan was to put it on this year's ballot. That would have been extremely ill-advised right in the middle of the Trump administration. The Justice Department would have instantly instituted an investigation and could have cut off UC's and CSU's federal funding, potentially billions of dollars. The bill has been amended to hold the election in 2028 instead, but that's only marginally less terrible. Trump will still be there for 2 months, and more importantly, we don't know who the next president of the United States will be. DeSantis, Rubio, Vance? If it is, it could cost our schools billions. And as the bill is written now, it's completely unnecessary to make such a momentous decision 2 years ahead of time. Even supporters of preferential treatment based on race, and again, in California, there aren't that many of them, they should oppose ACA 7. It will result in political and legal precedents that are not to its sponsors' liking, and it's a potential financial catastrophe for California. For these reasons, and for so many more that I'd be happy to talk about in the question and answer period, I hope that you will oppose this bill.
Thank you. In addition to that, if we could just have the gentleman, if you wouldn't mind just stating your name for the record. You didn't introduce yourself in the beginning.
My name is Frank Chu. I'm the president of Californians for Equal Rights Foundation.
Excellent. Thank you so much. We'll now hear from additional opposition witnesses here in the room. If you could use the mic at the railing, please state your name, organization, and position on the bill. Thank you.
John Perryman, speaking for myself as a retired teacher who taught at Luther Burbank High School in South Sacramento, 95% minority school in the 1990s up through 2019, both post and prior to Prop 209. Making racism legal again is what ACA 7 does.
Please just your name, organization, and position on the bill. The opportunity for longer forms of comment come from the two witnesses that provide support and opposition testimony. So if you could state your position on the bill, either support or oppose.
Opposed, so I don't get 2 minutes.
No, you do not get 2 minutes.
Good morning. I'm Tony Guan. I came from Silicon Valley Chinese Association and also Equal Rights for All PAC under the leadership of Mr. Ward currently. So we are strongly opposing to ACA 7. Please keep the racial discrimination illegal. Thank you.
And again, want to remind folks, name, organization, position on the bill. Thank you.
Eva Zhao from Equal Rights for All PAC and Californian for Equal Rights Foundation. I strongly oppose ACA 7. Thank you.
Vice President of the California Family Council, Greg Burt, in opposition. Thank you.
My name is Yun Luo. I'm a California parent. I strongly oppose ACA 7.
I'm Sue Xu. I represent Follow Our Hearts, Californian residents group. We strongly oppose this bill. Thank you.
Hi, my name is Emily Yu. I'm a California voter, and as a parent and a concerned citizen, I strongly oppose ACA 7. Please keep the discrimination illegal. Thank you.
Good morning, good afternoon. Maimon Schwarzschild, professor of law at the University of San Diego, speaking in my own name and in my own behalf against ACA 7.
My name is Sting from California voter. I'm opposed to the ACA 7. Please keep discrimination illegal. Thank you.
Hi, Madam Chairman and fellow committee members. My name is Betty Mo Young, and I am a fellow California voter, a concerned parent, and I highly opposed to ACA 7 against the discrimination on the racial. Thank you for having us.
My name is Yelin Mendel. I'm a California voter. I'm strongly oppose this bill. Thank you.
My name is Charlie Huang. On behalf of Elk Grove Chinese Association, we strongly oppose ACA 7. Thank you.
I'm Kirk Thompson. I'm here on behalf of my wife and kids, and I would like you to vote no. Thank you.
My name is Shaomei Zhang. I'm a voter and a concerned parent and educator, also representing a business and housing network. I strongly oppose ACA 7 and urge no vote on the bill. Please keep the discrimination illegal. Thank you.
My name is Nanzhong. I'm a California parent, and I strongly oppose ACA 7. I'm with a nonprofit named Students Who Oppose Racial Discrimination, also SWORD for short, and we're currently suing the University of California for racial discrimination against Asian Americans. If I may take 20 seconds, I'll present 2 data points to the audience here.
No, unfortunately,
Okay,
especially because I want to keep the rule consistent with everybody. I hope you can understand. Thank you.
Yeah, I oppose.
Yes. Anybody else? Seeing no other members of the public rising, I will turn it back now to the committee. I see Senator Gomez-Reyes with her hand raised.
Thank you, Madam President. I would like to ask if you could respond to the opposition's argument. Would ACA 7 or narrowing Prop 209 allow for racial or sex discrimination?
Defer to our.
I'll defer to my witness.
Yes, thank you so much, Senator Reyes, for your question. No, because why? Because the U.S. Constitution Equal Protection Clause is still in place. Why? Because California's state laws against discrimination is still in place. And those laws would still apply with or without ACA 7. As you know, the California, particularly the Equal Protection Clause for the U.S. Constitution, under that the courts have interpreted under strict scrutiny for the lawyers in the room. Strict scrutiny does enable for institutions, public institutions, to express compelling interests and to narrowly tailor their policies and strategies. Even the U.S. Supreme Court decision in the Harvard-UNC case also makes recognition of the strict scrutiny analysis. This is an effort of California to basically say, let's go with federal laws on anti-discrimination, which the Supreme Court has upheld and spoken in several regards, including the recent one that the opponents have mentioned, but more importantly, allow California to close the racial student equity achievement gap, and to do so smartly, narrowly tailored to meet the needs of the students, all aspects of the students.
If I may, I both agree and disagree.
I apologize, ma'am. If the committee member does not request to seek out your response, then there's no back and forth that happens here. That there are rules in this committee, and that's how this committee operates. Senator Gomez-Reyes.
All right. Well, I just wanted to also make sure that we understand, because the Black Caucus, as well as the Reparations Task Force, made it clear in their report the urgent need to make sure that we clarify for all government entities what is permissible by law and the Supreme Court and what is not permissible. We made it very clear that if the Supreme Court has ruled on it, we don't touch it. It is the law of the land. But we also have to recognize, as we use discrimination freely, and I think it's too freely, because there's actually two definitions of discrimination. So if you Google it, there's two definitions of discrimination. One is the act, practice, or the instance of unfairly treating a person or group differently from other people or groups on a class or categoric basis, such as race, religion, gender, and others. The Black Caucus knows something about that in our history, and we are vehemently against that definition of discrimination. But there's another definition of discrimination that I think is lost on us, and that is just the act of making or perceiving a difference. We have fruit on the table. There's an apple and there's an orange. There's a clear difference between the two. We have a group of students who need tutoring. We want to make sure that the tutoring, though, is done in a way that meets the specific needs of different groups. And so we want to make sure that schools know that there is a specific modality to ensure that tutoring is more effective for African American students. That doesn't mean that other groups don't get tutoring. It just means that the tutoring is done in a different way to meet their particular needs. And that is not illegal. And so what we want to do is make sure that we clarify for everyone what is permissible, whether you're a county or a city or a school board or a school district. But the way things are being done right now and the broadness in which it was not intended to do is stopping people from getting the help that they need in a whole host of categories. Is stopping them from getting what they need that can improve their quality of life and their ability to thrive in the state of California.
Thank you both for that. I heard from the opposition that this was allowing for discrimination, and as an attorney in reading your proposal, that's not what I read, but I wanted to have that confirmed. My other question is, how has Prop 209 affected racial equity in education?
I would just first start off by saying that the reason why the Black Caucus is so supportive and feel the need for this is that
I'm sorry, Assemblymember Jackson. I want to make very clear that we do not have members of the audience that yell across the room or speak across the room while we have other members speaking, whether that is the assembly member or any of the witnesses here if we're engaging with them and asking them questions. If that is not something that members of the public can follow, we will clear the room. Assemblymember Jackson, you can continue.
Sure. So we have noticed and we have seen in the data that there is clear disproportionality when it comes to how African American students are treated and based upon how other students are treated. And you can see it throughout the data, whether you look at discipline rates, whether you look at test scores, whether you look at all those different ways of doing it. And all the research shows is because we are not using the type of modalities that are helpful to African American students, because there are districts who believe that they are unable to do so. And so Prop 209 has had a detrimental, devastating effect on African American students in higher education and in the K through 12 system. And what we're trying to do is making sure that we correct those things now that we see decades of data that's moved forward. And I'll ask my witness if they want to answer any other.
Thank you so much for the question and for your response, Assemblymember Jackson. There is no doubt that Prop 209 has created a chilling effect arguably, understandably, around the area of contracting and employment, but ACA 7 still keeps those in place. What the Black Caucus in particular is focused on is the public education component of it. Immediately after Prop 209's passage, there was a chilling effect on data collection. Even to know the problems that we see today, the data that has been in the courts, and as we see today, we are able to collect data. Not only for African American students, but for Latino students and for API students, and particularly around disaggregation of API student data too. Two is there's been a chilling effect on outreach for a long period of time because of the fear of Prop 209 and what people thought it meant. That outreach, focused, targeted outreach, came to a halt. Fortunately, thanks to the legislature and various code provisions, you have resolved that, and it's become clear that focused, targeted outreach is allowed to ensure that everyone gets the news. So we are still seeing some elements of those chilling effects. I just gave you two very concrete ones of the past 25 plus years, and one of that is around addressing closing the student racial equity gap. It's persistent. We're having students fall behind unnecessarily. We need to see the students wholly.
Thank you. Thank you, Madam President.
Thank you. I want to make note of something, just given that it's now noon. We have an hour and a half to get through 9 bills. We've gotten through about 10 bills so far, and so I just want to highlight that for the committee, because I know we still have several questions. I know that we have members who want to ask questions of the opposition, and so I just highlight that so we can be mindful of time as we're going through this process. Senator Choi?
Thank you. Many key points have been raised already regarding this bill by the opposing witnesses. California voters have repeatedly affirmed the principle behind the Proposition 209. The government should not discriminate against or grant preferential treatment based on race, sex, or ethnicity. Yet ACA 7 moves California away from that principle.
No, it doesn't.
By opening the door to race-based decision-making in our K-12 schools. As the only Korean American serving in the legislature, I am particularly concerned about the impact that this proposal could have on Asian American students. We have seen the race-conscious policies disadvantage students who have worked hard to succeed academically. Families should never have to worry that their child's race will be used against them when determining access to educational opportunities. We should absolutely help struggling students, but we can do so based on income, academic need, language barrier, and other measurable challenges, not the race or color of the skin or ethnicity or country of origin. Race should never be a determining factor in K-12 education. As you know, that many affirmative action discriminated against Asian students in college admissions before. So many lawsuits rose out of that. Let me ask you a question. Can the author identify the specific educational programs that the California schools are currently prohibited from offering because of Proposition 209? And explain why existing need-based programs are insufficient. In other words, any students falling behind academically in the classroom, regardless of their ethnic race, base, or skin color, they are entitled to get the support, and they are getting the support.
Senator, they're not getting the support. That's why we're doing this bill.
So can you specify what programs are prohibited because of these racial differences that they are not learning, they are not getting help?
Well, as I've stated before, and that's what's in the analysis, is that we're saying that we're clarifying what it is because it's being overutilized at this time. And we specifically stayed away from higher education because, number one, the Supreme Court has done a ruling on it. And we understand the concerns of our API brothers and sisters when it comes to higher education enrollment. And so we don't touch that in this bill. Now, one thing that we know is not happening in our higher education, not higher education, our public education programs, is that we know, and research shows, and I'm more than happy to give you as many journal-authored, peer-reviewed research on this, and that is that different groups have different ways of learning, and in many cases is through cultural differences. And it just so happens when it comes to African Americans is that our culture is also tied to our race. And it is due to a very, very much concentrated effort since before the founding of this nation that we have a set of experiences that if they are not honored, they are actually creating harmful educational environments to us. Now again, and this is what I think is important, because I'll never expect you to truly understand my experience, like I'll never truly understand your experience. But what we're asking you to do, and what the Black Caucus is asking you to do, is understand that we're not making this up, and that we have seen over decades, I've seen it going through the educational system myself here in California, that we are treated differently. We are not given what we need in the way we need it. And just like in this bill, we have honored the API's community's experience by making sure that this has nothing to do with admissions into any programs. This has nothing to do with access to any programs. What this has to do is that we both get educational support, but it may look differently between us two because we might learn differently, we might accept information differently, which is also a scientific fact. And so, as you all are going through your talking points right now, I'm asking you to respect the Black experience and not try to use your own experience that is different from mine as a weapon against me. Because that is not right, and I would never do that to you. So at the end of the day, what we're saying is not to give us more than anyone else. But when you give it to us, like you're giving it to everyone else, give it to us a little differently so that we can make sure that we benefit from the services that we're getting.
Your explanation raises many questions. I've been a teacher in the classroom, university settings. When I have students like this, I don't teach differently. I teach my way. And there are many different races. And then obviously God created individual differences. Some do well in many things, some do average, some don't do well. And that the color or race doesn't mean anything. Even we had Barack Obama president excelling so well, and not necessarily that's a black caucus is concerned that the black race will learn differently. Does that mean that the Asians learn differently, white people learn differently, some other races of people will learn differently? I mean, in the classroom situation, we teach all one way, the teacher's way, according to curriculum or methodology they have learned. And obviously, regardless of race, among whatever 50 people here, some will understand very well, but some may lag. That is a natural phenomena. So that means, are you suggesting that, hey, certain group of people, racial group learns differently? That means then if that's the case, then by the race-based classrooms should be created? I don't understand that. We should be all treated well, and if there's some people need it, regardless of skin color or race, but their background or male or female should be treated equally, and they should be provided extra help, which we do. And this is a constitutional amendment proposal. It doesn't have to change the basic principle of 209 that to eliminate any form of discrimination based upon race or ethnic background or color of skills or ethnic origin, whatever. You know, but this is changing the Constitution, saying that treat me differently, away from the principle of 209. Don't you agree?
I don't agree on the basis of a few things. Number one, we're talking about K through 12 education, which is a totally different pedagogy than it is for higher education. Secondly, just because you say you've provided me an intervention doesn't mean that I benefited from it. What's equally as important is how that intervention is delivered. And what I'm saying is that there are specific ways that we know that are more, that levels better outcomes by the way the intervention is given, not just the fact that you gave an intervention. And what we're saying is the current interventions that are being provided to our children are not sufficient. And Prop 209 at this point, as it's being understood, is a hindrance for us getting what we need. And so all we're asking for us to do is to clarify so that making sure that everyone knows what can and cannot be done. And at the end of the day, it still upholds the intent of Prop 209 as well.
I'm sorry. Unless the Senator Choi request for you to respond or to offer comment, we can't have a back and forth. And, you know, I want to remain consistent on that with everybody because this is about creating a fair process. Senator Choi, do you have any other questions? I have both Senator Cabolden and Senator Ochoa both who have questions and comments.
The urgency of the time we need to finish this one, but this is a very important enough that requires a constitutional amendment, so that it takes time and a lot of idea exchanges. You know, very important issue is right now being discussed. Intervention is, you know, fine, it's welcome, but it is done differently because I'm different race. I don't understand that. So that means the teachers will have the teacher preparation class should be raised. Hey, when you are teaching certain A type of race, teach this way. B type of race, teach that way. So are you suggesting that? Which I don't agree. I don't understand that at all.
No, we're not suggesting that.
So
I've been very clear.
Is not effective for certain.
What I'm trying to, and I really need you to listen to every detail of my words. What I'm saying is that when everyone is receiving, everyone is a diverse classroom. They're receiving the same teaching modality.
Yes.
And then after that, you are starting to see that there are some in the classroom who are not receiving the information so that they can actually know what's going on in terms of learning the material. What we're saying is that there then needs to be interventions, usually done after school.
Yeah, extra help.
Extra help.
Yeah.
So what we're saying is, though, when you receive that extra help, there's different ways on giving that extra help. And what we're asking for...
Constitutional amendment.
But you're not, but that's why you're not listening to me. The Black Caucus is saying that it is necessary because what we see on the ground. And so it may not be necessary for you and your community, but it is necessary for ours. And so what we're saying is, and unfortunately, there are, you use the word race, I use the word culture. It just so happens that the way we have been treated in this country, that race is tied to our culture. And so for us, it's the same thing. But for you, it could be different. And so what we're saying is that we know that there are clear ways that we can improve academic outcomes for different groups. But the way to do that will require us for doing something differently than what we're doing today. And when we advocate at the local level about what we need, the constant refrain is we can't because of Prop 209. So this ACA clarifies what you can and cannot do and still upholds the Supreme Court rulings that have come down when it comes to issues of unfair discrimination.
I fully understand, and as a minority member myself, living in this country, all different forms of discrimination I have experienced. And black culture, since you are preferring to use the, rather than race, the culture, black culture, I understand how important that equal treatment was necessary. So 1964 civil rights movement led by Martin Luther King, notably, and through the struggles of history that we know of, ups and downs, ugly and beautiful, all different ups and downs that you have achieved, we have achieved, and other minority members who have immigrated after that the civil rights movement and the rights has been somewhat achieved, we appreciate it. So I really appreciate that approach that black culture has raised and demanded the equal treatment against any form of discrimination. Treat me, we are human beings, treat me the same way. That was the basis of the civil rights movement, right? But now you are telling me, don't treat me differently, we are different. So that's a contradicting.
No, it isn't. But I mean, I would love to have further conversation with you. I think that this actually has been a healthy discussion, by the way, and so I really appreciate it. and has allowed for us to offer more context. But I just think that we're coming to two different conclusions, and I respect what your argument is. We're just making the case that all of our research shows, as an African American community, it says that Prop 209 continues to have detrimental harm to our community.
Alrighty, I'm going to go ahead now and turn it over to Senator Cabalden, and then we're going to go to Senator Ochoa-Bogue after. Senator Cabalden.
Thank you so much, Madam Chair. And I have a couple of specific questions for the witnesses, but just as a preface, having being one of the 3 API members of the Senate, and having served on the Asian American Admissions Committee at UC Berkeley, and having worked pre and post Prop 209 in this space and trying to grapple with it, I appreciate why we're here, and we're dealing with a constitutional amendment because Prop 209 inappropriately amended the Constitution, right? It's the Assembly member is not proposing a constitutional amendment for no good reason. There's no other way to achieve the objectives that he's trying to get to. But I have a couple questions for the witnesses, and it's partly in the context, even though I've worked on this and and supported Proposition 16. I think the specifics of this issue aside, the choice of the legislature to place on the November 2028 ballot, which may be the most important, even though we say this every time, the most important election ever for the entire world, that we have to pay close attention to what we're doing in that election. And I want to understand in particular, how and why we think the result might be differently, but also I'm reflecting on what does it mean for that election if we center it on this question. But both the opposition and the support made some pretty broad claims here, but without any specifics. And so I want to really get into this because we should abolish the notion that pre-Prop 209 it was an equity nirvana. That before Prop 209 that Black and Brown and Asian students were plentiful on campus and succeeding, and that it was not the case. It was not the case. When all the tools that we say now are essential were there, we were not. We were only slightly further behind than we are today. And so let me start with the support witness, if that's all right, Madam Chair, because you indicated this would allow us to close the equity gaps, and we haven't actually heard any specific. Which is why I laid this question about what specifically are we talking about? If it's not admissions policies, which a lot of the Prop 209 research afterwards showed it was admission policies that caused the decline in Black student admissions. If the bill doesn't touch that, what magic counseling or tutoring program is going to reverse centuries of structural and institutional discrimination has created this? So, given when UC's own advice has been that programs targeted by race or gender that don't provide preferences and benefits that aren't generally available to all, or that are not targeted by race or gender but are targeted by factors that support the mission. There's a whole set of criteria out there. Can you give one or two examples of a project, a program, or a policy that we have reason to believe would make a breakthrough in terms of equity, particularly for African American young people in California?
I would say I would probably know better than she does.
I'm more than happy to answer, but I'm always mindful of the sponsor of the bill. So
fair point.
I've given one of the examples of the idea of when additional academic assistance is being provided. There are clear modalities. For instance, the Freedom School model that has been adapted to improve literacy for African American students, and that entails the choice of curriculum, the choice of books, and the way that you deliver the lesson is a clear Afrocentric intervention to improve the literacy rates of African American students that is unlike any other program. and does not deliver, that delivers the best results for African American students. So I would say that was
but are school districts or colleges or others currently interpreting the law to prohibit that model? Because I think that's the question. It seems like
correct.
The university
and the answer is yes.
Has tried to adopt more and more of these kinds of models, but this obviously applies to all of public education, not just to UC. But
correct. And the answer is yes. So would you agree with?
Absolutely. Because of what we talked earlier about the chilling effect of what people see as what Prop 209 is and is not. And so two comments. First of all, it's a 2-minute remark. I'd love to unpack more because these policies and strategies in the last 25 years, there's been more research around the work. You're absolutely correct. It wasn't nirvana 25 plus years ago, but we have been getting much more research around growth mindset, stereotype threat, belonging. You heard the prior bill around the issue of belonging, et cetera. There's been an enormous amount of research around being able to close the racial student equity gap based on these great scholarship work. And there's been pockets of success within them that we have seen. There's fear of that. We talk about, I really appreciate Senator Choi's comment.
Yeah, I don't want to, I want to stay narrow to the question, because I also have questions, a similar question for the opposition, just very narrowly on specific programmatic. I'm familiar with the research, and I agree. It's a very large claim to say that these edge cases, essentially in Prop 2, the things that are currently not allowed or not perceived to be allowed by Prop 209, but would be, despite the Supreme Court's, not just its direct ruling in the Harvard case, but also more generally the legal principles and standards that have been set forth, that there's that there is a set of programs and policies that would result in that. But let me turn to the opposition, which is the opposite question, because you've described this as about the fears about discrimination, what have you. Given the federal jurisprudence on this and the exclusion of admissions and what have you, can you describe a specific program or policy that you're concerned would become legal under ACA 7 that is not currently legal under both state law and the Constitution and federal jurisprudence?
Well, I just should start by saying, of course, I've said that anything that gets instituted under this is going to go into court and will almost certainly lose.
Yes, but that's not my question, so I would ask you to...
So is there anything that would survive? I don't think so. Nothing that's being suggested. Now, it has to be litigated, and it's going to, in the meantime, be the subject of Title VI compliance things from the federal government. So that could well cause the University of California and Cal State University to lose their federal funding. And I think that's the point I was trying to make, that this is a tremendous risk to these universities. I think the big ticket item here is going to be financial aid. All across the country, it has been routine for the last few decades for schools to basically surreptitiously discriminate on the basis of financial aid, which is kind of a very odd thing when it's given that when we're talking about higher education, students fill out their FAFSA form. We know which students need.
Yes. So, but
and yet,
excuse me,
there's a lot.
I still have the floor. The question is at my discretion. So, my understanding of your testimony and your response just now is that you believe that even if financial aid started to be applied differently in California based on this legislation, that it would still be violative of federal case law.
They have to go to court.
So my question, but the essence of my question is, what is it about a modification or a repeal of certain provisions of Proposition 209 that would open the door that is not already, that's discriminatory in your view, that would not already be protected from your point of view by the federal case law?
I think once the stories get out, and most of this is hidden, so it can't be litigated easily, but once the stories get out, I do believe that the court, as presently put together, would find that this is unconstitutional. I think it's a pretty easy case for most of all of this. Remember, Prop 209 only prohibits discrimination and preferential treatment. So all the talk about things that aren't preferential treatment, aren't discrimination, they have nothing to do with Prop 209. But it feels like in this room we're actually debating Brown versus the Board of Education instead of anything else. Because
Thanks very much for your response. I think the do you have a specific? Okay, a specific.
Very
program,
specific.
Again, a specific program that would not be barred under your understanding and ours of federal case law and Supreme Court decisions, but would be allowed under Prop 209 that currently is not.
Okay, so Californians for Equal Rights Foundation sued UCSD regarding there is a grant specifically only given to one race, and we sued them last year. And they immediately rescinded the program, even though it was 42 years old. And it would be permitted if ACA 7 were passed.
Because that lawsuit was under the terms of Prop 209 and not under the terms of the Equal Protection Clause or other federal federal case laws on discrimination.
That one was litigated in both federal and California Constitution.
Okay.
And there's another case.
Madam Chair, I know that the time is tight, but I do think this is an important issue, and it's why Proposition 209. I didn't support it in the first place, but it's not contributing today to these protections because the federal case law and the decisions of the Supreme Court and the changes to the standards for every topic, every program, every policy. That Proposition 209 way back when in the last century was intended to prevent from a discrimination perspective. Federal law now does that already. And so we haven't heard under a lot of questions of any not a single example of a program that would not be defeated at the federal level, but that would be allowed if this bill were to proceed. That would advance discriminatory outcomes for any California, including API California. And so I'm not totally convinced on the other side either, but it does seem to me that the concerns about this measure opening up lots of discrimination are not well founded, given the changes in the case law that already exists. So thanks, Madam Chair, for the indulgence on the time.
Thank you, Senator Ochoa Bogue.
Thank you, Madam Chair, and I'm trying to go as quickly, but I think, so I resonated with the same concerns with Senator Choi and Senator Cabaldan in that I'm still trying to look for the modalities that you are trying to be able to basically have access to that are not currently available now, that could not be possible right now with our current system with Prop 209. And I'm still trying to, and I know you said the Freedom School or the Freedom was an example, but I'm still trying to look to see what modalities are you referring to that that need a race exemption in which you are trying. So that's what I'm trying to get at right now on that end. And I still don't quite understand where that race, because I understand that your race and culture are the same, which is why I would probably argue on the sense that, well, if it's culture, then there's nothing that you could have access to that would prohibit you from contracting with such a service. But I'm trying to understand what modalities you're looking for, what resources you're looking for that do not allow you to use the culture-based under a current system.
Okay, I will refer to my opening statement, and that is ACA 7 aims to clarify Section 31 of the California Constitution to curtail the abuse and misuse resulting from improper application of Prop 209. So as you can see, we don't make very many changes to Prop 209, but we add clarifying language to make sure that local governments or any agency in the state or locally understands more clearly what Prop 209 is and what Prop 209 isn't. Because as you know, that even without a lack of clarity, it can still stop things from being done, even though legally it may still be available. So that's why we stress the fact that we're clarifying what Prop 209 is and what Prop 209 is not.
And I understand that concept, which is why I'm trying to, for the record, try to bring light into what modalities or what services are you looking at that involve race or that clarify with your particular Constitution amendment that is not available right now. What does that look like? What is that, so that we can understand what that is?
Well, I think the simplest example that we already gave was the idea of making sure that the type of educational help or assistance that's given, that making sure that school districts feel, from a legal standpoint, that they are able to use current research and interventions that are research-based, that are specific to a population.
Examples?
Well, I said literacy is one example.
But how is that delivered differently, which is a race or a culture component or a race component?
That is delivered differently by, number one, making sure that it may be a different selection of books that are being used for literacy.
So culture.
Correct. It could be making sure that there is more interaction in the intervention. Making sure that...
Examples, where was the race-based part of it?
An example of, well, I mean, that's our point. It's more cultural-based, not race-based.
Okay, culture-based.
Right.
So what does that look like that cannot be done right now?
Well, again, it's not about cannot be done. It's
yes.
clarifying to make sure that districts know that it can be done.
I understand that, but what does that look like that would bring hesitation to the forefront about school districts applying that that modality or that?
Well, the problem is that because our culture is directly related to our race, the fact that they would say, okay, it's time to provide literacy and literacy intervention. And so we are going to make sure that we provide in one classroom, there may be a one modality used, and another classroom there could be another modality used.
That's still not answering the question as to what is it that would prohibit
Again, it's not about prohibition, though. That's my whole point. You're focusing on prohibition. We're focused on a permissive language, not a restrictive language.
Permissive language, because right now the hesitation would say no because of why. Why is that?
Oh, because we can't do something specific. We cannot provide an intervention that's specific to African Americans.
Such as an example.
I already. I'm trying to. Maybe you don't understand. The example is a modality such as the Freedom Schools model, which is a whole different curriculum and a whole different way of actually teaching it. And I'm more than happy to provide you with that curriculum.
But I think that's what the public needs to understand, Dr. Jackson, is that I don't think people really understand why this is needed as to what practices are not available right now or accessible if it's based on culture. And that's what we're trying to figure. That's what I'm trying to get that out of you so that people can understand what exactly is not able to be provided right now, that you need to have clarification as to what this means, because otherwise people are not going, all they're going to focus on is, you're providing preferential treatment for someone based on race, rather than trying to clarify what practices are not currently available right now because of Prop 209. And I think that's where I'm trying to get.
I would refer the public to Ed Trust West Black Minds Matters report that outlines a whole plethora of things that that many schools are reluctant to do.
Okay, because culturally speaking, one of the things that I was looking at, and of course I can't, as you said, you know, I'm a Latina. I can't speak for your experiences, but overall, I think we're human, and as human beings, I rather focus on what we have in common, and try to focus on that end. And as a student, as an English language learner student that I was as a child, I can tell you that. You know, I had experiences that you probably did not experience, and I completely understand, but it was more of, you know, language accessibility when I was a kid. I was 8 when I started learning English. Opportunities that I missed because I didn't speak English properly, math experiences. So there's a lot of things that I can look at academically, language barriers that that were not available at the time when I was a child in Hawaii, especially in Hawaii when I was a kid, that I can understand based on needs, right? So that's why I'm trying to help you make a point, but I don't think we're getting there, or I don't think any of us are getting to the point that we're trying to get that that across. But regardless. There are things, so that was my question. I do have a question for Dr. Harriet. Give me 1 second. Madam Chair, through the chair, of course.
Yes.
I'm trying to be for Dr. Harriet. You suggested that if the Justice Department under Trump, DeSantis, Rubio, or Vance decides to undertake a compliance investigation of the UC or the CSU systems, it could end up costing billions. Why would that be, and how does federal law apply here?
Well, you know, what ACA 7 attempts to do is to loosen up Prop 209. It exempts only those things that came under students for fair admissions. That, you know, only admissions. That leaves open lots of other things, including financial aid, including lots of things that higher education could engage into. So, you know, what people need to understand is that the federal government has the ability to cut off all the federal funding that is received by any given entity, such as the UC system or the CSU system, that's in violation of Title VI. And as I suggested to the senator here, the things that this would authorize would be violations of Title VI. And so they aren't limited to cutting off the funding that is specifically related to the activity that the discrimination is going on. So if the financial aid office is discriminating, or you know, some other office within these systems is discriminating, that doesn't mean that they can only cut off the funds that deal with financial aid. To the contrary, they can cut off all the federal funding. It has not always been that way. There was a Supreme Court decision in the 1980s, Grove City versus Bell. And in that case, the Supreme Court said, no, the federal government only has the ability to cut off a piece of the funding, the part that has to do specifically with where the discrimination is found. But civil rights activists hated that decision. They went to Congress and they said, no, 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 we want the federal government to have more power. We want them to be able to cut off every nickel that the federal funding recipient gets. So Congress passed that law. President Reagan vetoed that law, saying that's putting too much power in the hands of the federal government. They shouldn't be able to completely cut off federal funding. But Congress overrode that veto, and as a result, we're now in a situation where the federal government is in a position to really play hardball when they think that something is discriminatory. And just recently, Columbia University had to fork over $300 million in their federal funding because of what the Trump administration considered to be a Title VI violation. Well, the UC and CSU, they're about 20 together. They're about 20 times the size of Columbia University. Columbia University is a small private university. So if we can just look at it in terms of 20 times larger, figure that the federal funding may be about 20 times greater, we're talking about billions of dollars. I suspect, it would be less than the 6 billion times 20. The 6 billion times 300 million times 20 is 6 billion. But the risk here to these universities of attracting the attention of first the Trump administration, and now if there's a DeSantis or a Vance or a Rubio or some other conservative president elected in 2028, the risk to these universities, I think, is very great. You're basically taking, the red cape
Thank you.
and
Thank
waving
you.
it.
I appreciate your answer. I think I will not be supporting the bill today, but I do want to emphasize the fact that aside from economics, aside from economics probably being the underlying need, which many a times when we don't have, or students come in without a lot of financial security, there's a lot of needs, or experiences that are not provided for. And so I look more of an economic perspective as far as trying to address a lot of the needs for, you're talking about the whole child. With the local funding formulas that we have right now, really focusing on our English language learners, focusing on economic disparities that we have that impacts many Black and Brown community members, and opportunities when it comes to education as far as, reading material. We have ethnic studies right now where, depending on the school demographic, the schools can cater literature based on the ethnic makeup of those particular schools, that would, incentivize different cultures to be able to have more keen interest in what is being taught, to try to get them in and get them engaged into reading perhaps, or history, whatever it may be. I think we have a lot available within our scope of resources and funding that we give our low socioeconomic demographic, the additional funding that schools receive based on that. Also, when we have our schools that have 55 or more of their student population not meeting the economic threshold of financial security, they get additional funding for schools, and then how those schools that administration goes and contracts for services or provides those services to meet the needs of children's reading or math or physical, psychological. We have so much available right now, and I haven't seen where and how, what specific practices are race-based. And I know it's going back and forth with the culture race, but I don't see anything that would need or suffice to, or not suffice, but need race to be excluded or needed or exempted, that could not be under the cultural practice, such as, when I meant, if we had a predominantly Black school, why they couldn't, have more books on the Black American experience or history. So I'm not seeing where we're missing that point. So with that, I'm going to respectfully, I have other cuts, but we can talk separately on that end, but I don't see the justification.
I'll put the example in my closing remarks, and then we can have follow-up conversation.
Thank you for bringing this forward, and thank you to our witnesses, and I will respectfully not be supporting the bill today.
All righty. I'm going to go ahead and close us out. I certainly had questions for the witnesses. There's no longer time for that. We have about 40 minutes to go through 9 bills. So a number of things. First and foremost, ethnic studies has not been implemented. We have not allocated funding towards ethnic studies, and so we've not gone through full implementation. And so I just want to make that very clear to everybody in the room. Until we have money that is appropriated, we will not see ethnic studies be implemented. I know there's some school districts that have taken it upon themselves to move forward their own policies. That is their prerogative, but the bill that we passed here at the state legislature has not been implemented. That's first and foremost. Second of all, I want to be mindful of something that Senator Cabaldon also mentioned, which is placing this issue onto the ballot. I'm not sure how many people in the room were there for the Prop 16 campaign. I was. I worked at the Campaign for College Opportunity at the time, and frankly, I did not see an effective job being done of reaching out to our communities of color and explaining this issue. And it was frankly embarrassing. And I was really disappointed, and I saw my communities in the San Gabriel Valley, be left behind and left out of the conversation. This conversation around affirmative action, Prop 209, the reason that we even have these discussions, the concerns about the Equal Protection Clause, all of these discussions that we're having here. Assemblymember Jackson, what you were trying to get to is making sure something that this gentleman was kind of speaking to a little bit earlier, and that is being able to provide funding, grant funding, right, to specific groups so that we can create specialized programs to support students based off of their specific needs. Now, I'm familiar with this because before I came to the legislature, I used to do research that was focused on different groups, including our Asian American communities, as well as our Black communities, our Latino communities, and all of the nuances there. And what we have found repeatedly, and particularly for the API community, is that there is a lack of understanding of the needs of this nuanced community because we do not disaggregate data. And so because our school districts get so nervous when they're going through and implementing programs to try to address the specific needs of our diverse groups, they shy away from doing so because they worry that it violates Prop 209. And so I went to a school where we had no white kids. It was all Latino and Asian. And so when our school was moving forward programs that was, at the time before Prop 209 passed, focused on helping our API community understand the history of the Asian American struggle here in the United States, to help our immigrant API students establish a sense of belonging within the school district, those programs went away because there was concerns that they were discriminating against students. When we have, as there are several bills in this space that are trying to move forward, HSI or BSI programs, there's no funding attached to those programs. We just recognize that those institutions are serving a large number of Hispanic students, or a large number of API students, or a large number of Black students. We don't apply any funding towards those programs because of Prop 209. I am of the personal opinion that I think that it would be a good thing. It would be a good thing to provide additional financial resources to try to address the specific needs of the API community, of the Black community, of the Latino community. I understand that there's some folks in this room who disagree. So I am supporting this bill. I have concerns, as I've mentioned, about what this is going to mean should this ultimately get placed onto the ballot. I understand the legal concerns that have been raised. That is obviously something that needs to be explored. But we do need to do a better job of communicating to our own communities why these issues are important. Because frankly, there is so much misinformation around these issues that I've heard over the last 10 years. And we need to get better at describing how we can create and target programs to improve better outcomes for everyone. I want to see all of our diverse communities succeed. And that's my job here as the Senate Education Chair. So there is work to be done here. I want to be super clear, including the partners. I'm very familiar with the Education Trust West. They know me very well. Chris Nellum is a good friend. We have our work cut out for us. So Assemblymember Jackson, I will turn it over to you to close.
Thank you very much, and thank you for your patience, and thank you for the thoughtfulness of all of our colleagues. You know I love you dearly. Two things. Number one, in terms of a specific example that the Black Caucus has run into, I'll refer you to AB 2774 by Wilbur Pearson about 2 years ago, where we tried to make sure that there were LCFF dollars targeted specifically to student groups the lowest achieving student groups. And because the lowest achieving groups, lowest achieving group were African Americans, we were told we cannot direct funding towards them. Because even if you go by economics, it is still not getting to the students who need it the most. Which is why in local control plans, you start to see this category of it helps every student. And every time you say every student, every time you say anything less than what it is, a particular group, then the funding actually never gets to them. And ever since the local control funding formula existed, we have seen that. But we were particularly told that we cannot do it because of Prop 209, and that's in regards to the LCFF. The messaging is equally as important. And the reason why we tried to get this done last year, but because of our traditions, we always wait till the last minute. That only gives us max 5 months to make the case on some of the most complicated issues. So why do we move it to 2028? So we can actually get the time to educate people and to put together the case in a respectful way that it deserves. But if we continue to do it the way we've been doing it, we never make the time to make sure we fully educate communities on the complexities of issues like this, that incorporates history, that incorporates trauma, that incorporates various dynamics depending on the various diversity of California. And so the Black Caucus sees this as one of its top priorities and really an existential threat to our ability to be able to thrive here in California. And we see it time and time again. We're not making these things up. These are real things. And if the shoe doesn't fit, then it doesn't apply to you. But that doesn't mean that it should not apply to our specific circumstances. And again, we do not touch higher education. We do not touch any type of preferential type initiatives. But what we are saying is, if there's groups that we see that are falling through the crack, we need the ability to rescue them. And that's all the Black Caucus is asking for us to do. So with that, respectfully ask for an aye vote.
Thank you. So the motion for ACA 7 is be adopted and re-referred to the Senate Elections and Constitutional Amendments Committee. Do we have a motion? We have a motion by Senator Gonzalez. Secretary, can you please call the roll?
Senators Perez?
Aye.
Perez, aye. Ochobog? No. Ochobog, no. Cabaldon? Choi? Cortese? Cortese, aye. Gonzalez? Aye. Gonzalez, aye. Reyes? Aye. Reyes, aye.